This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about an arson-for-profit scheme that was defeated by the equitable remedy of rescission, and why rescission of insurance for even an innocent misrepresentation of material facts is sufficient to defeat a claim, and that there is no need to prove arson to defeat an arson-for-profit scheme if the insured simply failed to honestly obtain the policy of insurance. Back in 2003, I examined a person named James E. Mitchell under oath on behalf of his insurer, United National Insurance Company. Mitchell admitted to misrepresenting material facts when he applied for the insurance. As a result of that examination under oath and the testimony of the underwriter, United National decided to rescind the policy rather than accuse Mitchell of fraud and arson for profit, but still refused his claim for fire damage and offered to return the premium he paid. Of course, in an expression of chutzpah, unmitigated and unlimited gall, he sued only to have the court conclude that rescission was appropriate. In James E. Mitchell individually and as trustee of the Mitchell Family Trust versus United National Insurance Company, a decision of the California Court of Appeal on March 8, 2005, the Court of Appeal established a standard for dealing with rescission of an insurance policy in California. It concluded that an insurer made, under Insurance Code Sections 331 and 359, rescind a fire insurance policy based on an insured's negligent or unintentional misrepresentation of a material fact in an insurance application, even though there was evidence that all of the misrepresentations were intentional. The right to rescind exists because of the material misrepresentation and because there was undisputed evidence that the insurer relied upon the misstatements of material fact in an insured's application for insurance. The summary judgment granted by the trial court was affirmed. And that was because even before making the decision to rescind, the insurer obtained from its underwriter a sworn declaration as to the materiality of the facts misrepresented, and that underwriter so testified when the case was brought up for material misrepresentation and for a summary judgment. During the policy period, the building was destroyed by arson. The arsonist, an acquaintance of Mitchell's, perished in the fire. He did not realize that the door he entered in had no doorknob on it, so that when, after setting the fire, he tried to leave, he couldn't open the door to get out. The trial court granted summary judgment. Mitchell had purchased the building in February of 2000 in the name of his trust. On April 11, 2000, Mitchell's brokers applied for insurance to Deborah Messina of Excess and Surplus Lines Insurance Brokers and authorized underwriter for United National. Mitchell represented in the application that 1. The property to be insured consisted of a 3,420 square foot commercial building. 2. The building was to be used by Mitchell as a video production studio and offices. 3. The business to be conducted in the building had $20,000 in payroll and generated $300,000 in receipts. 4. There was no existing insurance on the building. 5. The building had no uncorrected fire code violations. 6. The building had a burglar alarm. And 7. Records and Filmworks, Inc., later changed to James E. Mitchell, was the purchaser of the building. In fact, the 7 representations were false, including the fact that the building was subject to a City of Los Angeles abatement order stating that the building could not be occupied without a clearance or repaired without a permit and contained such deficiencies as being open to unauthorized entry, littered with combustible debris, excessive dry reeds or vegetation, broken windows, damaged or missing doors, damaged exterior wall covering, damaged interior wall and ceiling covering, and deteriorated flooring, and no permit had been obtained for corrective work on the deficiencies. Carl Robinson, on November 22, 2000, a business consultant with a prospective buyer for the property, became an acquaintance of Mitchell. Mitchell gave Robinson the keys to the property for the purpose of showing it to prospective buyers. On November 22, while Mitchell was in Chicago, Robinson set fire to the building and was killed in the ensuing blaze. Although evidence indicated that Mitchell had retained Robinson to burn the building, his death in the fire made proving Robinson and Mitchell were working an arson-for-profit scheme were difficult, if not impossible, and therefore United National limited its denial of Mitchell's claim on the ground it had rescinded the policy based on material misrepresentations in Mitchell's application for insurance. Mitchell admitted that the application for insurance submitted to United National contained inaccuracies that he claimed were not material and were solely the fault of his brokers. The trial court granted summary judgment in favor of United National, finding as a matter of law and the undisputed facts that the information sought by United's underwriter and denied to it by plaintiff's false answers and omissions was material to United's decision to provide insurance coverage. United National based its right to rescind the policy on California Insurance Code, including Section 331 that states, quote, concealment, whether intentional or unintentional, entitles the injured party to rescind insurance, and Insurance Code Section 359 that similarly provided, quote, if a representation is false in a material point, whether affirmative or promissory, the injured party is entitled to rescind the contract from the time the representation becomes false, close quote. And therefore, an insured's negligent or inadvertent failure to disclose a material fact in an application, that materiality is determined under a subjective test. The critical question is the effect the truthful answers would have had on the insurer, not on some average reasonable insurer. For the purposes of rescission of an insurance policy, the materiality of a misrepresentation is determined by its probable and reasonable effect upon the insurer. The application questions in this case plainly impacted decisions on whether to insure the premium or the premium to charge. In his response to defendant's statement of undisputed material facts, Mitchell even admitted that questions concerning the ownership, size, and condition of the building, the nature of the business to be conducted, and its payroll and receipts, and the existence of insurance under the FAIR Plan were factors impacting either the underwriting decision or the amount of the premium and coverage, and that his answers to these questions may have affected the decision to bind coverage and the amount of premium. United National's representative, Ms. Messina, said she relied upon Mitchell's answers to the questions, including the condition of the building, its use, and whether it was covered by insurance. Contrary to Mitchell's argument, Ms. Messina had no obligation to verify the accuracy of the representations because she was applying the fact that an insured is obligated under the covenant of good faith and fair dealing to truthfully apply for the insurance. The undisputed evidence showed that there were material misrepresentations in Mitchell's application for insurance. United National had the right to, and did, rescind the policy based on these misrepresentations and concealments of material fact. The trial court therefore properly granted summary judgment, and that judgment was affirmed, and United National was awarded its costs on appeal. In my opinion, it is often difficult to prove that an insured was involved in an arson-for-profit scheme. Mitchell was out of the state when the fire occurred, and the arsonist died in the fire he set. Evidence indicated that Robinson was only trying to sell the property to United National on behalf of Mitchell by destroying the building by fire. Since Robinson's death made the intentional arson fraud difficult to prove, the lies on the application were used to defeat the fraud, since although Mitchell understood fraud and hired probably Mr. Robinson to set the fire, he did not understand insurance and the effect of the lies he made to get the policy, only to find that liars never prosper, and certainly Mr. Mitchell did not prosper from this fraudulent insurance scheme to use arson to profit from an insurance policy. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, where you can subscribe and receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also gain access to the more than 4,600 blog postings. You can also subscribe to the videos on YouTube and rumble.com. And if you do, I'd appreciate a like button on YouTube and the thumbs up button on rumble.com. And if you enjoyed this and learned from this blog and this video, please tell your friends and colleagues about the blog and the videos so that they too can subscribe to the blog and the videos. And if you wish further detailed information about insurance claims, and insurance fraud, please, for a very small fee, subscribe to my Locals Community or my Substack publication. Thank you for your attention.